spoken for and on behalf of organizations or different stakeholders, but one important aspect is our data, our financial or health records, our family data, our children's data. Do we feel that we are more secure now?
Many of these organizations may not have clarity on what they collect, where they collect, how they store, where they store. So the beginning should be from a data audit, understanding all their ecosystem.
I would like to exhort all the privacy professionals, either in corporates or in consulting or in the legal fraternity, to kind of come together and realize that this is a watershed moment for the country, right? How we decide to implement this law is going to lay the foundations of how data is managed in the years to come.
Hello and welcome to the Vantage Point. I'm Santosh Vikram Singh, and today we are discussing one of the most important regulatory developments of the year. Yes, the newly notified Digital Personal Data Protection Rules 2025. Much awaited rules finally activate India's modern data protection regime and have significant implications across industries, from startups to large tech, from financial services to government systems. And to help us decode this, I have two excellent guests with me here. My colleague Rajesh Vilakat, partner at Fox Middle and Associates, and Pooja Deshpande, head of privacy implementation at Identified. Thank you both for joining us today.
Thank you. It's a pleasure.
Thank you, Santosh, inviting me for this.
To start with, can you each briefly introduce yourself and your work in this data privacy landscape? Pooja, let's begin with you, and then Rajesh.
Sure. Thank you so much. And again, big thank you for inviting us to this podcast. I am heading the implementation for our DPDP governance platform called Privi. This is a part of the largest suite of offerings at IDEFI, which is an integrated identity management platform. So we have products that help organizations onboard customers to fraud and risk prevention, and also help them in their DPDP and data privacy journeys. From a privacy perspective, we have a DPDP compliant solution, and I'm here to kind of see how the rules are going to impact you as an organization as well as a customer, and what is it that you can expect to see in the coming days.
Rajesh.
Hi, thank you, Santosh, again for inviting me to this podcast. I head the privacy team of our firm. As you know, Fox Mandal being one of the oldest law firm, we were very careful about creating a specialized group for privacy compliance and advising clients on privacy aspects. And this is an important event for us because all our clients were all throughout were asking what is your privacy law in our country and how you have to comply with. Now the rules have come out, and this is a good opportunity for all of us to be clear and concise and precise opinions we can give.
Thank you, Rajesh. Thank you, Pooja. Rajesh, as you said, the rules are out. It's been a long wait. There have been a lot of pressure from different countries, different stakeholders, but finally we have something here. Uh, Rajesh, to start with, why do these DPDP rules matter so much in today's context? And then what makes this moment a turning point for India's data protection journey?
Hey, if you look at our ju- jurisprudential evolution, we have recognized privacy data protection as a fundamental right many years back, and but we didn't had a clear position on what are the compliance requirements, how our data governance should be, what are the rights of the data subjects. So there were a lot of uncertainties. Of course, we had some provisions under IT Act, but it is not structured, rigid, and prescriptive. So now we have a law. Now the rules are announced and it is published. Um, so now we have certainty in what is expected from all the stakeholders, and what rights the data subjects will have, or data principles will have under the Indian law. So that is the major development. So that's what the implications of this notification.
Perfect. Pooja, coming to you from your perspective, and since you have seen GDPR so closely, what is uniquely Indian or significant about the way these rules have been framed or this law has been implemented?
Uh, Brilliant question there. I think the law is quintessentially Indian because it manages or it tries to strike a balance between innovation and protectionism in its true sense by empowering data principals. Uh, Control over their own data by making consent as a fundamental crux of this entire law. I think it just signals that we as Indians want to exercise a higher control over our own data. Therefore, consent is so crucial for us. And therefore, we want to decide how that data is also being used. Unlike GDPR, that prefers, say, a contractual basis or a legitimate interest or a public interest as its primary basis of processing, and consent being relegated to the last resort for legal basis of processing, at least from an operational perspective. India is putting consent front and center of its entire operationalization regime and is giving the emphasis on informed consent, explicit consent. So we want our data principles or we want our people to exercise their rights and to get value out of their own personal data rather than just calling it a very harm based or a very protectionist approach. And also, a very important thing is the data principal rights. So, we have the additional right of nomination, which is very fundamental to Indians. So, even post demise, or if there is something that needs to be corrected or something that needs to be regulated, if I may say, in terms of what personal data was shared, I think that is also something that we are looking at doing. So, that's very interesting from an India landscape.
Right. Rajesh, GDPR came into picture about 7, 8 years ago. So there was certain expectations from Indian, data protection law. From a micro point of view, do you think all the expectations have been met?
Yeah, to a large extent. And I feel that we have done some corrective measures as well. The fundamental flow of GDPR, what everybody was observing is consent. Though there was a consent regime, it was completely ineffective because citizens or the data subject do not have the right expertise to decide what kind of consent to be given. So the consent mechanism didn't work well because data subjects, for them to avail the services, they are forced to give the consent and they automatically click buttons. In our Indian law, this is getting rectified because we do have specialized agencies coming in who may have better capabilities to decide what consent can be given. And so the consent manager regime is something really, really new. And it is, I think it is a growth from GDPR.
That's a good to hear that. But we as a user, do you think our approach is going to change? We are still going to click without reading those terms and conditions. We are going to just share the data, left, right, and center. So the user behavior will not change. Whether this new law or regulation will help us in any way.
Yeah, interesting question, but answer may lie after 12 months. But assume that India data consent is managed through professional consent managers, and they do have clear processes of identifying what consent to be given. And there is specialized technological tools enabling the data principal to decide what consent to be given. When that is in place, we will have clarity.
If I may just come in over here, I think to the point that Rajesh made about technology partners and technological controls driving effectiveness of consent or a good consent. I think that is absolutely crucial and critical. And the government has also recognized that to some extent because they have come out with a business requirement document of what a good consent management system should look like, right? So this is already there in the public domain, and they are already nudging and signaling data fiduciaries to start revamping or start looking at their internal processes, technologies, so that they can collect this consent in an effective manner, right? So in this document, there is about what should be the language that you should inform the data principal when you are seeking consent. Or in case there is a change in processing, what additional communication should go out, right? What are potential dark patterns to look out for, right? So the onus is actually on the data fiduciary to present it to the data principal in a way that they're not wanting to click forward, but stopping, reading, and then moving forward. So the accessibility of a notice and making it in a layman's terms is very, very crucial, because now there is no reason for a person to just click forward. It's not jargonized, it's not long pages. It has to be interactive, it has to be creative, it has to be something that a person, the minute they see, within a few seconds, understand what is being shown to them and then move on. So that is where the entire making consent effective comes into picture. So data fiduciary is enabling consent for their own customers, and also consent managers acting as an additional layer for the data principals to exercise their rights, and therefore then making a more empowered privacy framework within.
Perfect. Let's move on to the immediate impact of this notification. Let's talk about what becomes enforceable immediately, and what transitional provisions kick in, and how does this shift the legal landscape for data fiduciary. Rajesh?
The immediate changes, we do have a data protection board now. There is a notification that it will be located in Delhi, and the board will have 4 members. So essentially, the regulator is available now. Is announced, location is announced. They said it is going to be a digital office, so physical location may not have much impact. And we have created a selection committee, and that selection committee may identify suitable people maybe in a couple of months. With regard to the substantive provisions, nothing is enforceable now. We will be still governed by old IT Act provisions, but this is a period for everybody, all the stakeholders, to get themselves prepared, make themselves change their patterns of doing the business, look at their internal practices and identify the flaws, go along with the act and the rules.
Okay. Pooja, how do these translate into on-ground operational changes for organizations? And if I could simplify this question, what starts moving from theoretical compliance to actual implementation?
Brilliantly worded, sir. So we are already seeing changes or waves coming into the way organizations are perceiving this announcement, in the sense that now organizations are putting together teams in place who will now look at what processes need to change, what technology needs to be implemented or onboarded, so that they can start complying or start demonstrating compliance towards these requirements, right? So they plan out what needs to happen in the next 30 days, 90 days, next 1 year. And, so that by the 13th of May 2027, they are fully compliant on day zero. They are able to collect those consents, respond to those grievances, do internal impact assessments, and, create those reports that can then be submitted further on. But there are some early movers as well who have already started implementing. So their planning and design phase was 6 months ago, and they have now started updating, say, for example, their cookie banners, right? A lot of them are also looking at rolling out as a beta testing of the explicit consents and notices in 22 languages, so that when they hit the go live date, they will have strong tested processes in place so that they can then collect those explicit consents. A lot of them are also looking at their data mapping and data discovery exercises. So, knowing what personal data they already have, how much was already consented, what was collected as a part of services that were already being provided. So, do they now need to look at retaking those consents, or, cleaning up their pipes when it comes to using that for marketing, for example, or analytics, and so on and so forth.
Interestingly, Santosh, the requirement of notice is unique here because uh, all our websites are in English. Almost 90% of Indian digital presence is in only in one language, English. Whereas the law mandates that the notice should be in 22 different languages. And Each data subject should have the option to choose the language that he prefers. And so he has complete informed understanding before giving a consent. So this notice requirement itself is a big challenge.
Rajesh, rightfully mentioned that all these consents have to be taken in their vernacular languages. Now, how difficult or challenging it is to have an API and convert that page from English to their vernacular language.
Uh, um, to be honest, there are the challenge doesn't lie in translation, but it lies in transliteration, right? So today, we all know that there are some tools available on the internet that help you translate the entire page. But what the real challenge is that the translation to make sense. So in a legal document, so for example, in a notice, if I am telling the customer that I will be using your PAN to verify your identity, if I just simply translate, it will say I will use your tawa to identify you as an individual, right? So all of these challenges are there where organizations will have to put a little bit of effort or thought before saying that, okay, I'm just going to write an English notice and just hit translate and it will get translated. Having said that, it's not that difficult either. There is so Privy platform has that transliteration function available. The government has its large language translation model, LLM model called Bhashini, which provides organizations with enough and more tools to kind of leverage that and achieve some level of transliteration.
Absolutely, absolutely. Uh, Now, Rajesh, if I'm a data fiduciary listening to this podcast, what do I need to do in the first 90 days? And while explaining, just walk us through the legal and governance priorities, includes documentation, those notices, consent flows, grievances, mechanism, etc. From the data fiduciary point of view.
See, if you look at the current understanding of data fiduciaries in our country, all of them will say that, hey, there is no law here. We are absolutely free to do whatever we want. The first 90 days should be to realize themselves that no, that is not the case anymore. And it is a time for me to internally look at what to be done. Otherwise, I will have penal consequences. It is first time in an Indian legislation, these kind of large penalties are put in. 250 crores, 200 crores, and the minimum is 50. We don't know what is the parameters at which these penalties will be imposed, whether every case will have 250 crores of penalties or whether it will be subject to the size of the data fiduciaries, or will it be based on the gravity of the negligence. That details will come up in another 12 months or 18 months. But essentially, they need to realize that they are subjected to a law now. They need to look at what data they collect now and how they need to store it, what kind of security systems they have, what technology measures they have, whether they are taking right consent. So it is a time for an overall review of their data, digital presence in every aspect.
So, Rajesh, we understand there are no exceptions and there are no exclusions. Are there any, or it applies to anybody and everybody? If you have an organization, if you are a data fiduciary, if you fall in that category, it applies to you. You are not excluded. And why I'm asking this question, because as you rightly mentioned that the penalty is so high. The POSH has been there, legislation in India for many years. And recently I was reading a report which says that not more than 30-40% companies have implemented it. So what, we are not aware country, or we don't respect the law?
See, I had an occasion to interact with an Australian High Court judge, and he was giving an observation about India and Indians and Indian legal system. Maybe contextually very correct here. Majority of Indian laws were created by British, and it was something enforced upon us by a foreign force. And unfortunately, even after independence, we continued that same pattern. But at least in privacy law, I believe that phase is over. We have given enough time for everybody to think analyzed, multiple drafts, all stakeholders' opinions were considered. So I think it is more consensual now. Looks like will be a greater compliance in relation to data protection, unlike Porsche or other, in general, every other legislation. So
Right. Pooja, coming to you, of course, on the same topic, what does this look like at an implementation level? How should privacy and infosec teams get started?
Absolutely. I think to be very honest, the time for planning is past, right? If you do not know what you need to do as on date, then meeting those 18 months of implementation deadline is going to be difficult, right? I'm not saying impossible, it is difficult. So I think what uh, all the infosec or privacy or whichever teams are tasked with DPDPA compliance, and to be honest, some legal teams are also kind of taking up the mantle in certain organizations. So I would strongly urge them to start looking or start uh, thinking about how can they make it operational starting today, right? So say for example, if I have a website, do I know what cookies are on the website? So run a cookie scan, deploy a cookie banner, right? For example, if I have an existing grievance mechanism, right, then can I train my grievance agents, the ones handling the grievance mechanism as on date, in handling privacy grievances as well? Can I start a parallel data discovery exercise and see what data I hold in which systems, how much of it is encrypted, how much of it needs encryption because of the sensitivity aspect of it? Because there is a security aspect also included in the rules, right? There is a rule 6 that says you need to have reasonable security safeguards to prevent any misuse of data or unauthorized access to data, aka a data breach. So therefore, do I know what where that data is? Where is it lying? So starting a lot of these in parallel is something that they will kind of benefit them when they come to the closer to the 2027 deadline. Yeah.
Pooja, additional question here, of course, barring this consent managers and the workforce, we have enough workforce, trained workforce rather, to handle this situation now.
Ah, uh, I would want to say yes and no, both. Yes, because there has been a lot of awareness in the privacy adjacent space since the law came in. And mind you, we had something known as a PDPB in 2019, the Personal Data Protection Bill, which was the precursor of the DPDPA. So there and enough and more existing regulations do touch upon data privacy in some form or the other, right? So, say for example, you have the IT Act SPDI Rules 2011, which did talk about having a privacy policy displayed on your website. So that's why you would see even today you have a lot of these privacy policies. So there is something known as the digital lending guidelines, right, which the RBI mandates and requires the regulated entities, the banks, the NBFCs, to seek explicit consent to have a privacy policy, disclose who are the third parties with whom data is being shared, so on and so forth. The telecom regulators have already talked about privacy, and the DNC, or the Do Not Call register, that has been around. TRI always keeps coming out with certain regulations on digital consent and telemarketing consent, so on and so forth. So what I'm trying to get at is privacy as a subject was diffused in the Indian corporate landscape or in the Indian legal landscape. It has now become super focused. So that means that yes, almost the entire workforce did have some idea about what privacy is, but however, now operationalizing it and demonstrating compliance with each of these, right, regulations and the culmination in the DPDPA, that requires an additional skill set, or that requires an upskilling for for this entire existing ecosystem. So therefore, the yes and no answer. But I feel that the current generation of DPOs are the first generation of DPOs in this country, right? Data protection officers or privacy managers, and they will actually set the pace of how India demonstrates compliance, or India complies or operationalizes the right to privacy.
Perfect, perfect. So let's discuss some of key provisions of this legislation and identified about 6, 7 of them. And to start with, we have already touched upon this consent and consent managers. I wanted to ask at the very beginning whether there is a mandatory provision to have a consent manager. Let's say i- a small organization. Do we really need to have a consent managers, or we can have our notices or provisions on app and website in a such a way that we don't have to have another layer of it? Rajesh?
I'm not very clear on it.
Was that
The reason is uh, the structure of consent manager, according to the act, is more like an agent of data principal. He is expected to act on my behalf, so he is my agent. But looks like the rules are given a more corporate structure to it. The conditionalities, if I look at, a consent manager should have 2 crores of net worth on. It should be a company. It should have technological enablement. It looks like more like a tech intermediary. I was assuming that it will be an NGOs or organizations with more charitable cause who will help to create a appropriate consent mechanism, maybe working on CSR funds. But to my surprise, when the rules were announced, the characterization of consent manager is a completely corporatized organization. And I'm not still clear what is the revenue model for these consent managers.
Pooja?
Um, I completely echo what Rajesh said that the commercial viability of a consent manager needs to be thought through, and maybe some more clarity coming in from the authorities would be very helpful. But if I were a small business owner today, right, or if I had a small digital presence in the country today, I would think, what is it that is in my control? What is my exposure, and what can I do to become compliant with this law? To that extent, and to what implementations I would want to do I definitely need a consent manager? Maybe not, right? Because I can govern my relationship with my customer very conservatively speaking, right? If it becomes a mandate, yes, I will definitely have to integrate with consent managers. But as on date, we'll see what processes I may have to integrate, what, say, changes I will need to do on my website, get a consent management solution of my own, right? To seek explicit consent and manage those consent artifacts in my own control. So, what I would do.
And I completely agree with both of you that we definitely need more clarification. But what my interpretation with my limited understanding of this legislation is that if we are able to manage this issue, that taking a consent, managing those things, and if somebody wants to withdraw the consent and etc., we don't need another layer of consent managers. However, large companies, for example, if somebody is taking your data for whatever services you're procuring, instead of notification coming from fiduciary directly, the notification would come from their service provider, which is a consent manager. And the moment you accept, the moment you give a consent, it gets forwarded to them. So, though the consent managers are accountable to the principal data principal because it's them, they are handling our data, but they would be paid or compensated by the data fiduciary. So they are accountable to the data principal, but paid by the data fiduciary. So this is my understanding, but definitely, with the time we would have more clarification on this topic. Another point is that the rule says that consent managers must be data blind, just like Google or any ISPs have been saying, we don't read your data, we don't read your emails, so you can completely rely upon us. But how will this work in the real world? Unless these consent managers read the data, they would not be able to take it forward.
No, I think that's the beauty of innovation, to be very honest, because I have seen platforms, consent management solutions be data blind. So, for example, when I seek consent on behalf of the data fiduciary, what I'm doing is I am effectively assigning an anonymized ID to you as a user of that product, right? Now, when I'm a consent manager, I don't need to know whether user's name is Pooja or user's name is 123. I just need to know that user gave consent for name, email ID, and phone number to be used for these purposes. And I can inform this to the data fiduciary, right? And then the data fiduciary can internally map this user anonymized ID to their internal systems, right? And n number of times that Pooja comes back to the data fiduciary, in n number of times those IDs could get generated and get attached to the internal ID. And this is a prevalent practice quite hashed out in the current space. So achieving data blindness is not something that is completely new. Also, this is already happening in the account aggregator framework, right? That is there in the banking space. Now, how do they transpose that? That is to be seen. But this is not unheard of, and this is very much achievable, and we are already doing it. That's what I think.
Perfect. Rajesh, we talked about security safeguards, and you also touched upon how important it is. The rules expect reasonable security safeguards. We need your interpretation of these reasonable security safeguards, and more so, it highlights encryption, masking, access controls, log monitoring, etc., etc.
Yes, see, the word reasonable security practices is there from our IT Act rules days. There was some indication of ISO 27001 or any other like standards is what was there in the IT Act. In the new law, we don't know because nothing has come out so far. They are still only using the word reasonable security standards. If you look at the Rule 6, they are using the words of encryption, masking, like terms. But what should be the quality of encryption? What is the quality of masking? What technical control should have on all these activities is yet to come up. And that's why I earlier answered. It's very difficult for us to say whether government can dictate security standards. Security is an evolving subject, and the technology is moving so fast. Very difficult for a government agency to prescribe, okay, A is the prescribed standard or B is the prescribed standard. If they do so, it will be more disastrous because the technology grows so fast and very difficult for regulators or the government to uh, prescribe it on an ongoing basis. So I guess this ambiguity will remain, and that will be the road for lawyers. And any breach incident, the security standard will be a question to be debated. There will be expert uh, requirement in all these prosecutions or penalty assessments. There may be a new industry on that side as well, assessing security standards of organization and confirming whether it is a reasonable security standard as prescribed by the law. And so that's what I was imagining. I'm not sure if Pooja has a different take.
So let me rephrase this for Pooja. Rajesh mentioned that there will be certain clarification coming from the departments. But do you believe that these SMEs or MSMEs realistically implement these obligations? Tomorrow they say that 27,001 or this audit or certification is needed. We understand SMEs are tech enabled, tech savvy, but what about those MSMEs? Can they implement these?
So nobody wants a data breach or a potential incident on their plate. But at the same time, the cost to comply with this to its maximum gold standard ability or to get it right all through and through is difficult and sometimes requires you to divert some very crucial resources that would otherwise have gone to building your business or your revenue streams to then, this. So this debate is always there. And But that is why I think the beauty of the law is reasonable security safeguard. And I was reading somewhere that the data protection board will be governed by the laws of natural justice, and that means that as long as the MSME is demonstrating compliance or demonstrating the will to comply, right, uh, looking at their circumstances, the kind of data they handle, the kind of exposure they have, I think in that case, if they choose, say, a simple role based access management control, right? Saying that only certain people will get access to the data. And then they say that we may not go for like homomorphic encryption or something that is very, very robust, but at the same time super, super expensive. But we will try to handle it through role based access control or through, physical security safeguards or XYZ things, right? Nobody gets access to the servers, nobody gets access to the information security assets, so on and so forth. As a small company, 5, 10, 15 member operation, right? So then I think that as long as they're able to demonstrate that they wanted to comply with it, they did whatever was within their means and the best to their ability, I think that is what will play a crucial role rather than looking at the complexity or the sophistication of the tool that they actually use to do reasonable security
You
safeguards.
sound very positive about it.
I I'm an optimist, and I believe that this law will help businesses rather than trying to pull them down, and that's why I think we are very different from GDPR in that sense, because we want data to be shared freely so that the people whose data it is get benefits out of it. Today, if I am a small store owner and if I can share my bank statements freely to get additional credit, I would want to leverage that. Right? Or I'm a student and I want to get that 25% discount on an e commerce store in a responsible manner. I would want to do that. Right? So we are an aspirational country. We don't want people to hoard stuff. We want them to use it freely. So I think that is what the law is trying to do.
Rajesh, Pooja is saying she's okay about sharing the data freely. Now,
Responsibly. Responsibly. So I also have the right to rescind if I realize that they are using the data incorrectly.
right. Coming to cross-border transfer, Rajesh, there are certain provisions that the companies must process data in certain jurisdictions. What are those laws and provisions related to cross-border transfer of data and how it is impacting these MNCs and SaaS startups?
Nothing is mentioned about cross-border data transfer yet. So I think we need to wait another 12 months. Definitely, this is not going to be as free. My gut feeling is there will be some controls on cross-border data transfers. But as of now, the present law available, except an indication that significant data fiduciaries will have some certain additional obligations in terms of cross-border data transfer. All other data fiduciaries are free to do or free to move their data wherever.
So Rajesh, you're saying if I'm wearing a data tracker device, let's say watch or band, can they take data away out of India and they use it in a way they would like to? Do we have any control?
No, except the regular consent mechanisms are to be complied with, or the legitimacy of user data should be always be concerned. But otherwise, as per law, there is no restrictions now, so you can transfer the data wherever you want, unless you are a significant data fiduciary. So if maybe Apple or Google, so in those situations, yes. Otherwise, as of now, they are free.
Right. You talked about those SDFs, significant data fiduciaries. Which are those companies qualify under these SDFs and what are those obligations for them?
Not clear yet, Santosh, because law is not categorized or no bucketing is done yet. I believe there is some indications from some schedules of this data protection rules that 2 crores users is the benchmark. I believe when SDF related notifications come, maybe the same numbers may come in.
Coming to you, what are those concerns about children's data? And of course, we have PAN card, we have Aadhaar card of our kids, and that data is fed in DigiLocker and other token system apps. Are there any exemptions, or it becomes like really difficult for all the stakeholders to navigate through this provision?
So there are certain exemptions that have come in one of the schedules. The number of the schedule is escaping me right now, but certain education institutions, certain medical institutions are exempted from the strict requirement of parental consent and processing of the children's data for certain activities. So there is an exception provided to them. But overall, if you're not in one of those exempted categories of data fiduciaries, then there are some very strict controls around how you can use the child's data, right? From whether so how you collect the children's data. So you need to have a verified parental consent before you even collect their personal data. You cannot collect them basis Section 7A. It is very clear. Only verified parental consent is allowed. Secondly, you also need to verify the identity of the parent slash guardian who is providing the consent for the child. I'm not talking about the PWD guardians that are appointed by authorities. I'm talking about cases where the natural guardian is not available and there is another person stepping in. So, identity of that person needs to be verified. Consent from them needs to be sought before you kind of collect that personal data or start providing services to that individual basis the personal data collection. Number one. Number two, you cannot profile or you cannot use that data for direct marketing, advertising, targeting. You cannot profile that individual or that child. So you know that this is a child user, so I'm going to keep sending them, say, communication about a new game or a new candy or something that is a children's product, right? So that also is not allowed. And no harm should come to the child. Like, to tie it all together, the requirement is that none of the processing should harm the child in any manner, right? And because the data protection board is going to kind of be an adjudicatory body, is what we've heard, case can be made on certain types of processing being harmful to the child, right? And harm can be monetary, can be psychological, physiological, any kind of harm that can be uh, proven before a court of law under the rules of natural justice. I think that becomes a very high threshold for data fiduciaries to then breach and say that, okay, this doesn't cause a harm to the child. So the law is very clear. The children's data is to be used extremely responsibly, and certain organizations that are required for children's activities like education institutions, health institutions, there is some relaxation to them. But otherwise, anybody else has to tread very, very carefully when dealing with children's data.
Perfect. Rajesh, another main feature of this legislation is the breach notification we need to comply with. So, in case of any data breach, just help us understand those processes, when exactly and in what circumstances we need to inform the data principal and the regulatory.
Oh, the rules have made certain provisions now. So what it says is immediately you need to intimate the data principal about the breach incident and the likely impact they may have. That is an immediate requirement. And you need to have within 72 hours. And similar intimation should go to the DPB as well. And once you do the analysis of the extent of data breach, you need to have a second notice to go to the DPP, detailing out the complete incident and more specifics to the incident. 72 hours from the breach was noticed. So essentially, it is very time bound. And I believe Indian organizations will find it really challenging for them to do that. And all over the world, reporting a breach is a concern because it has a reputational impact. It will have a long term customer impact. So the natural tendency is to hide so that this reputational harm is avoided. But the law is mandating you to do it immediate. There will be a huge conflict internally within the departments, say privacy office and the marketing team, how to report. All these I can imagine in next 18 months.
Pooja, let's imagine this situation. One particular airlines has our data. All of us use credit cards to book tickets. Now there's a data breach. How would they reach out to all those users whose data has been stolen? Do you think practically, as Rajesh rightly mentioned, it may not be feasible to reach out to them immediately? Of course, you can notify to the board, but reaching out to all those data principals immediately, are there any procedures, forms, and formats prescribed?
Yes, yes, there are a few, or that was at least indicated in the law. as well as the rules, that the Data Protection Board will come out with certain formats or forms, as you mentioned, so that the reporting is standardized and the reporting gives the information that is required for the Data Protection Board or the data principal to take the next steps, right? They've already given a brief indication in the sense that you have to inform about when was the breach identified, who are the impacted data principals, what are the impacted services. Also, when you are reporting the breach to the data principal, you have to tell them what measures they can take to protect themselves from any further harm or further breach, exposure of their data because of the breach. So yes, the Data Protection Board is indicating that they will come out with certain forms and formats to respond or to report the breach. And as regarding the mechanisms to reach out to their data principals, informing them of a breach, then I think they can leverage their existing communication channels, to be very honest, and send out a communication to say that, hey, we think we have suffered a breach or we have suffered a breach wherein your data could also be compromised. So please take additional steps, or we are here by reporting.
Good.
So I don't think it's that difficult. It can be done.
Right. Let's move on to the next point, which is a roadmap for the next 6 to 18 months. That's the kind of timeline we have. So, Pooja, to start with, can you just outline the implementation journey for these data producers from now until May 2027, including sequencing, staffing, tools, etc.
Absolutely. Like I mentioned before, we were already a week into this implementation, right? So there are about we have about 70 odd weeks. So I would recommend create tracks or verticals on what needs to be done for each segment. Consent and notice being one, data principal rights being one, obligations of data fiduciaries under the law being another, security measures being a third, and start looking at actionable items or actionable changes that you will need to make on the ground to do that compliance. So start with your cookie and consent management modules, implementing technologies. Started putting your policies and procedures in place that will govern all of this, so that internally you have an SOP or a playbook to say that in case I have a new product going live that is going to collect personal data, then this is the type of consent I will show, or this is the type of notice I will show and seek consent for, or this is how I will manage if a request comes to me for access or for revocation or for rectification, so on and so forth. So I would say take the law, break it down into actionable sections, and then for each of those sections, look at whether it requires a technology implementation or a process change, and then start on the journey for that change and maintain documentation of how you are doing that journey. So if I were to make it extremely high level but extremely actionable, I would say in the first 6 months, look at what consent and governance management platform you would need so that you can create those consent artifacts and those cookie banners to be displayed. Simultaneously start with your data discovery journey, so then by the time you are a year into it, you know which data is lying where, so that when you do put your data principal rights management things in place or your workflows in place, you know who to reach out to in order to respond to an erasure request or an access request. Next step is look at your security measures. Once your data discovery is done, you will know what personal data is lying in which state and what is the security that you need to attach to it, so that you can then demonstrate compliance on that front. And finally, also look at doing simulations or drills to respond to a breach and report a breach to the Data Protection Board, so that in case, God forbid, something like this does happen, you have a fully prepared team who knows what needs to be done at what time, so that you can meet those deadlines and do the reporting in a timely.
Right. Rajesh, other than what Pooja mentioned, what must companies do if they think that they must be classified under SDFs? Additionally, whatever Pooja mentioned, that's for everybody. But if you fall under SDFs, additional thing they need to do?
No, the what law says is there must be a data protection impact assessment done annually. Uh, and a audit requirement for significant data fiduciaries. Uh, so, impact assessment is a process where understanding each data sets and the connection requirements and looking at how that is going to impact in terms of the privacy rights. This assessment is mandated for significant data fiduciaries, but I would say that this can be done for everybody. And that may be a fantastic exercise for every organization to be fully compliant with. Essentially, assessing what data you collect and the basis of the collection and the legality of that collection, and looking at the where it is stored, how it is stored, and how secure it is, and how you manage those data. So, this assessment, department wise, organizational size, and looking at the security measures of it.
Pooja, what does audit or investigation readiness look like for what exactly we should have done these, ticking the boxes so that we are,
Right.
we are ready?
First of all, having a report that checks for your existing policies and procedures, whether they are aligned with DPDPA and whether those policy procedures are getting implemented or not. So, I mean, that's something known as test of design and test of effectiveness, operating effectiveness. So, as long as you're able to demonstrate that this has happened through evidences, I think that should make you feel a little comfortable in facing any additional audit coming in.
Right. Rajesh, what exactly enforcement triggers should companies be aware of? And also, please tell us about those liabilities and penalties.
Essentially, it says a penalty up to 250 crores can be imposed. DPB, Data Protection Board, is the adjudicatory body, and we have an appellate mechanism. And orders of the appellate board or the appellate forum is an executable order. Uh, so essentially, DPP orders may not be executable, but appellate forum order is enforceable. As Pooja said, I don't know the process under which DPP will evaluate it, what kind of evidence mechanism, what kind of trial is going to happen for this currently. So we need to wait for all that to emerge. If it is uh, naturally, it may be the size of the data fiduciary may be one of the indicators where the penalties can go up and low. Yeah. Or maybe the depth of the violation may be one of the indicators for deciding these. So the parameters of deciding what should be the penalty is not very clear yet.
Since there is still less clarity on this, can we take some inference from GDPR and kind of interpret or share our thoughts how the penalties have been, given there, and how similar penalties, can be expected here in India? So, have you seen instances under GDPR which we can relate or we can refer to, Pooja?
Sure. So, looking at the results coming out of the data protection DSAs, as they're called, I think data supervisory authorities. Every country having one, and then the European Data Protection Board coming out with some sort of advisory on how to interpret a particular standard. But what I see is a lot of the fines and penalties also come out of whether the processing itself was lawful or not. So, whilst yes, security breaches are super critical, but specific to GDPR or specific to the enforcement by the data security authorities, the questions are on whether the processing was lawful. Now, lawfulness of processing begins with the way the data was collected in itself, right? So, say for example, a company claims that they were processing this data basis uh, Section 7A. I'm just paraphrasing from the Indian context. So, if they claim that this was under Section 7A, but it is identified that it was not for a voluntary purpose provided by the data principle, but it was for, say, something that worked. So it was much more wider. So, say for instance, I gave the personal data to receive an e-bill, But now you start sending me marketing communication and you say that the marketing is because you gave me the phone number, right? To which the data protection board can say, no, phone number was given for receiving of e-bill, not for marketing. So for marketing, you should have sought consent. And because you did not seek consent, this processing itself is unlawful. And therefore now you are liable for a penal action, right? So that is exactly what the GDPR does. So they look at whether so say be the very famous EU-US transfer cases, the Schrems cases, right? Schrems 1, 2, and now 3 also. So all of these cases basically talk about whether the transfer of data was lawful, whether the processing was lawful. A lot of it also comes from not responding to data principal rights requests. So, for example, the turnaround time was 30 days and then additional 60 days, and still you have not responded, right? So, therefore, then saying that you have not complied with the law. So, for me, whilst yes, security breaches or those are going to be something that is going to be looked at, but they may also get into whether the processing itself was lawful or not, and some enforcement actions can come from there.
Right. Let's move on to the next one. What are those actionable takeaways for today? So, let's see. Somebody calls you, Rajesh, today asking what exactly we need to do from tomorrow. So, from a compliance point of view, Rajesh, what would you advise to company? And the same question for Pooja in terms of implementation. So, Rajesh, would you like to go first?
I would uh, ask whether we can conduct a data audit now, because many of these organizations may not have clarity on what they collect, where they collect, how they store, where they store. So the beginning should be from a data audit, understanding all their ecosystem in terms of collection points, storage places, and use places, and retention and deletion places. So this assessment should be done first. Then understanding who internally, creating a structure for them to regulate it better. So um, training the internal departments, making them aware, and then introducing processes inside the organization. Maybe an impact assessment of each of the critical data that they collect as well. So this process for a large organization likely to take a couple of months, maybe 3-4 months is a minimum period required for us to achieve this, and then creating policies on it. So as Pooja said in the beginning of this conversation, this 12 months is quite short period. If looking at the maturity of Indian organizations and the data fiduciaries in our country, when GDPR was enacted, one important question was who should DPO report, whether he should be reporting to the board or whether he should be reporting to the information security team or to the legal team. So similar questions can come in a larger organization here.
Pooja, implementation checklist.
For everything that Rajesh sir said. And my only would be that please start, don't even wait for tomorrow, start now. Please look at what you already have. And to be very honest, even for large enterprises, right, there is some level of documentation, some level, some muscle that is already built in terms of complying with the law, right? So leverage on that muscle. And then rather than waiting for you getting a laundry list of things to do, as soon as you identify there is something that needs to be done, start actioning it out. Start putting the email IDs or the contact details of your grievance officer, like who the person can report to in case there is a grievance. So as soon as you identify that this is something that needs to be done, please start actioning it out and then take it from there.
After listening to both of you, looks like there's going to be additional burden on companies, both financial and otherwise. Today we talk about ease of doing business, but looks like with this legislation, every entity has to spend at least one time on these new tools and the changes they have to bring in, and also annually they have to spend certain amount of money and time, etc. Rajesh, what do you think? How is going to impact startup ecosystem of Bangalore, of India?
No, anyone doing business should do business responsibly, and this is cost of doing the business. A citizen's right is absolute. It is fundamental. And if you are doing the business using citizens' data, do a responsible business. So there will be a cost implication, absolutely yes, but unavoidable it is. It's as like incorporating a company, annual reporting or annual tax payment. Obviously, this will be an additional cost which is not budgeted in earlier days, but you need to spend for it. There is no room for bargain or escaping from this obligation.
Let's hope government comes out with certain provision where they have certain incentives for implementing these rules, because as you rightly said, they had not budgeted for these additional expenses, and but they have to do it now in phased manner.
Uh, I think I will be remiss if I don't make this point here. I feel, as a privacy professional in the country, I feel this is not a cost. This is an investment. Because what has happened is, like we said, Indians are data rich before they became materially rich. If I want to responsibly use that data to my own advantage, right, I need to be able to demonstrate that I have control over it, right? So, as a data principal or even as a data fiduciary, right, today, like you said, today why is it that we are willing to incorporate a company rather than going for a sole proprietorship or a partnership, right? Because when you incorporate, you create credibility for getting access to credit and then growing your business, right? So this is really not so much as a compliance cost but an investment cost into cleaning up your own data pipes, into your own digital environments, so that what you collect is lawful, is effective, and that can unlock a lot more value for you. So that's my opinion as a privacy person and as a consumer and as a part of a startup ecosystem.
Absolutely. Closing perspective. As we wrap up, both of you, Rajesh and Pooja, last thoughts and final calls to action for businesses, data principals, you and me, and also government organizations.
My only request to the government is bring clarity to all these unattended provisions of DPDP, which they can maybe in 2 months or 3 months. I understand the concerns. Maybe they wanted to create the DPB and take their inputs before introducing any notifications or further clarifications. But on a data subjects perspective as well as on data fiduciaries perspective, important to know how it is going to be governed after 18 months. So, at least a greater visibility in terms of all these aspects where there is no clarity, that will be really useful.
Um, Adding on to what Rajesh said, I would like to exhort all the privacy professionals, either in corporates or in consulting or in the leave it fraternity, to kind of come together and realize that this is a watershed moment for the country, right? How we decide to implement this law is going to lay the foundations of how data is managed in the years to come. Be it AI, be it any other innovation that is beyond the AI, everything is going to be fueled by the data that you and I generate today, right? So I think what I would like to kind of look at is the whole community coming together and defining how is it that we want to use this personal data equitably and in a transparent, responsible manner, so that every individual and the individuals to come, the generations to come, can benefit and can adopt technologies without the fear of a surveillance state kind of situation coming into picture.
So, for last 1 hour or so, we have spoken for and on behalf of organizations or different stakeholders. But one important aspect is that the data of you and me, our data, our financial or health records, our family data, our children's data. Do we feel that we are more secure now? Do we feel that our data will not be misused? And there are enough provisions under this legislation which will give us some sort of confidence that yes, India is ready for tomorrow. Last thoughts, both of you.
Tricky, yes, Santosh, because there is a recourse mechanism now, and we do have an institutional framework to address these concerns. So these two were missing earlier. That is implemented now. Mm, Of course, how effectively and practically they will enforce this is something which we need to wait for. But we do have the structure now. Very helpful.
Pooja?
A resounding yes. I mean, in addition to having somebody taking accountability for ensuring that my privacy rights are maintained, the data protection board is what I'm referring to. Also, the onus on data fiduciaries to start thinking about this and start implementing procedures for either data minimization or purpose limitation. That itself gives me a little bit of comfort, saying that now even the ones who are processing data have to do it responsibly, right? And the fact that I am also an equal stakeholder because of the duties of data principles that are there, I think overall this law will give me some way of some semblance of security that yes, the data is going to be used responsibly. But like Rajesh said, it will only be a test of time. How the enforcement actually comes in it, that will define how responsible are the data fiduciaries.
Great. So thanks to our team for setting this up. Thank you, Rajesh. Thank you, Pooja. This has been a deeply insightful conversation. Really appreciate your time and effort for this, guys. Thank you so much.
Thank you very much.
Thank you, Santosh. Thank you.